filed a notice of tender payment. I'm challenging the jurisdiction.
Actually, that's not correct. The file indicates that you submitted an affidavit of poverty.
On the order, it did not specify how to pay.
It was your obligation. Mr. Freehoff, please
ma'am, I need to finish what I have to say. You cannot make a ruling over something that you don't know.
I'm sorry, Ms. Ballard.
You cannot make a ruling over something you can't know. You saying you don't know is an unacceptable response.
Ms. Ballard, what? I'm not going to call your case formally right now. Right now, what I'm looking for is how long do you think that it will take to present what you want to present to the court today?
To my understanding, has the court reviewed the affidavits that has been submitted?
Yes, ma'am.
Welcome back, everyone. This case doesn't feel like a normal court hearing. It feels more like someone stepped into court with ideas they learned online. The tenant believes she doesn't have to pay rent and brings papers she made herself to prove it. She uses phrases that don't mean anything legally and claims the law only applies if she agrees to it. The judge stays calm and patient first, but eventually he reaches his limit. Once that happens, things go downhill fast. Let's watch how the situation falls apart.
Okay, so what can I expect as far as procedure? How will this hearing go?
Well, so typically what will happen, because you are the movant, you're the person presentation that you would want to make. Sometimes people choose to do that. Some people don't choose to do that. But the idea is that if you wanted to explain to me what your position is in some shorter or different way from how you put it in the filings that you made, and then I would call on Ms. Akpati on behalf of her client to make a response. And then typically, because you're the movant, I would let you have the last word. And then sometimes I rule during the hearing. Sometimes I take it under advisement. It just depends on the circumstances. But if you wanted to make a presentation to outline verbally for me what you believe are the important issues, how long would that take?
I'm not sure. To my understanding, with this hearing, I was under the understanding that the affidavits that have been presented are fully understood, and that based on what I have submitted, that there would be a proper decision and ruling.
Okay, so I'm interpreting that, Ms. Ballard, as you wanting to rest on the materials that you've sent, and that's perfectly fine. Ms. Akpati, what presentation, if any, did you intend to make? I'm just trying to get a time idea of how long this might take.
5 minutes, Your Honor.
Okay.
From my position, I filed an affidavit of priority interest in the property. I don't understand how we can be at this point when I'm not a tenant and there's no contract for being a tenant. The other party, the opposing party, says that they have interest in the property, saying that they have a sheriff's deed, which is what it's a color of title. It's not the title. There's no position of equity with that sheriff's deed. So to my understanding, with there not being a contract, and I'm challenging the jurisdiction of this other entity, I'm requesting that this motion under the titles, under the Rule 60B, that, this is thrown out. It just, we don't have a contract. There's nothing to really argue here. So, it's clearly displayed and stated in the affidavits that I submitted. And bottom line, we don't have a contract. The other entity does not own this property.
Okay.
I have priority interest and equity in this property.
Okay. Thank you, Ms. Ballard. As I said, I have had a chance to review the magistrate court file and
She acts like rent is some kind of trick and treats the judge like an enemy in a game. But the law is simple. If you sign a lease and move in, you must pay rent. It's a legal agreement, not a personal belief system. If you don't pay for months, the law catches up with you. no matter what theories you believe.
Ms. Ballard, is that part of the order that was entered against you, which you are challenging here, right? That the magistrate judges, the purpose of this action is because the magistrate judge entered an order that said that you were not entitled to possession, and that and you're challenging that order. And I understand that part. But part of the order also requires that for you to challenge it, you're required to make some payment into the registry of the court. And my looking at the system, I don't see that any payments have been made. I think that that's part of Ms. Akpati's argument in a brief that she filed a couple of days ago, that you have not made a payment into the registry of the court to preserve your appeal rights. Can you tell me about that? If you have made a payment, and maybe I just don't have it in my system, or if you haven't made a payment, can you tell me the basis for that?
I have. They did not ask for rent. They didn't put in an affidavit to ask for rent. So, and there's no contract. But I have paid into the court of registry. The paperwork is there.
Can you tell me how much you paid into the court registry?
All of it. It's on a continuous basis until this matter is resolved. The last month and the remaining balance, everything is in compliance with the order from Magistrate Judge Brooks.
Ms. Akpati?
Your Honor, just to get straight to the point, no payment has been made. I did call the court this morning, and there has been no payment made. So if Ms. Ballard is saying that she has made the payment, could she provide to the court some form of evidence showing that she's made the payment? Because, again, as of 15 minutes ago, no payment has been made, or the court is not aware of any payment being made.
Yeah, I have looked in both the magistrate court file, which is often where those payments will go, and I've looked in this action, and the financial documents don't indicate that any payment has been made in either case, other than the original, I think, $103 filing fee that was paid by the defendant in the magistrate court. I don't see anything that indicates payment. I'm happy to follow up with the court because sometimes the clerk gets a little bit behind, but do you have any documentation regarding when you made those payments or the amount of the payment?
It was a couple weeks ago when I filed it into the court of registry.
Okay, what did you file? Did you file like a proof of payment, or what did you file?
It is basically a money order.
I apologize. I need to take a brief break for something. Hold on just one moment. Okay, Ms. Akpati and Ms. Ballard, I apologize for that brief interruption. Okay, so where we are right now procedurally is that...
Gives the court a paper she made herself and claims it counts as payment. But legally, payment must be real money or something officially accepted, like a money order or certified check. If it's not recognized by banks or the government, it doesn't count. Making your own document doesn't erase debt.